Hi, everyone. Abby, are you going to start us off or should I begin?
Go ahead.
Okay. Well, thank you, everyone, for joining us. I'm Jonathan Goldstein, co-chair of the condominium department at Haber Law, PA. I'm here with my colleague from Haber Law, Kristin Ferrer, as well as Ben Messerschmidt of Epic Forensics and Engineering. Before they introduce themselves, we would like to take a moment to reflect on the tragedy of the Champlain Tower South collapse. Tomorrow, it will be 1 year from that dreadful calamity that took 98 lives. And so at this time, we would like to have a moment of silence for the victims. Thank you. Thank you. On behalf of Haber Law and Epic, I want to express our deepest sympathies and profound sadness for the victims of the Champlain Tower South collapse and condolences to their loved ones. We grieve with them, and I know that the shadow of that collapse looms over nearly every minute that we work in this industry that we've chosen of representing, advising, protecting, and guiding condominium associations. Our practice of law and Ben's practice of engineering will never be the same. We'll discuss that today. And it's because of the weight of the responsibility we all share as attorneys, engineers, directors, owners, residents. That responsibility is now much heavier. And in remembering this tragedy, we will never forget the weight of this responsibility. So the point of today's webinar is to discuss lessons learned from the collapse a year later, discuss ways in which it has affected condominium associations, and the very recent legislation and local ordinances shaped by those lessons. So again, thank you for attending. Thank you to the Brickell Homeowners Association for hosting us, and Abby. And with that, I'd like to introduce Kristin Ferrer and Ben Messerschmidt. Kristin?
Hello, everyone. Thank you for joining us today. As Jonathan said, I'm Kristin Ferrer. I'm an associate attorney at Haber Law, and I mainly focus on condominium and community developments.
And good afternoon, everybody. My name is Ben Messerschmidt. I'm an engineer as well as an executive director with Epic Forensics and Engineering. We are a full service engineering firm, mainly very true to our name with forensics and engineering, but fully capable and ready to support any sort of condominium and HOA needs, given our vast knowledge and the experts that we have within our team. So thank you for joining us, and I'm personally happy to be here as well.
Okay, so with that, I think we're going to start by discussing the aftermath of the tragedy at Surfside in terms of how it's changed the lives of, the practice of, community association law, the role of directors, how it's impacted residents and owners, and also engineers like Ben. Since the tragic collapse, there have been a whole ripple effect of impacts, some very subtle, some very obvious. We've listed just a few of the more, obvious and significant ones. But I just, before we begin, I'd just like to frame the issue of responsibility. Since the Champlain Tower South collapse, I think it's very safe to say that we as attorneys and Ben as an engineer have never felt the weight of responsibility in our roles as much as we do now. And I know that directors have, I don't want to say all directors have changed their approach, but I know that associations in general are taking very seriously their obligations and responsibilities in light of this tragedy. And so I just want to highlight the fiduciary duties that directors have and the business judgment rule, because these are really issues that are brought to the fore when we look at a tragedy like this. First of all, the business judgment rule protects reasonable business decisions of the board of directors and associations. It's a long-standing legal doctrine. And basically, directors are held to a standard of care where they must consult with appropriate experts or individuals whose reliance upon whom is justified, committees, etc., in making their decisions. And directors can't just simply act recklessly or for their self-interest. And therefore, the opinions of experts, such as Ben, take on a very prominent importance. And that importance is only magnified exponentially by what has happened. And when we think of the gravity of the potential harm that was illustrated by Surfside, it just shows that the duties of individuals, involved with community associations, it's never going to be what it was before, right? Because of the stakes. Kristin, Ben, would you like to add something in terms of the engineering standpoint?
Absolutely. And I thought that was a very good tee off, Jonathan. So thank you. So with relying upon your professionals, I mean, attorneys, engineers, any sort of vendor, I mean, that's the reason why you're set up in the manner that you are as an association. But with what I've initially seen and the knee-jerk reaction almost to this collapse shortly thereafter, I know from my end is the term structurally sound or structurally safe, which I'm sure a lot of us have heard ad nauseum at this point. But a lot of our recent reports, because of the collapse, has really focused on those two words. Now, that is essentially, from an association standpoint of things, that is putting the responsibility more directly in the lines of the expert or of the engineer, someone like myself and like our firm. But we noticed that insurance carriers are really requiring that, even though the amount of insurance carriers within the state of Florida, whether you're in a single family home or a condominium, is like drastically reducing right now to like citizens or nobody, right? I mean, I for one, I mean, I got dropped by my current insurer, and I'm in a single family home. So Florida's market is not being very friendly in the first place, and Surfside did not help that whatsoever. But with that terminology of having an expert go ahead and say a structure is safe or sound, and really by putting that in print with an associated sign and seal stamp, I mean, that holds a lot of weight. So you can imagine that substantially more due diligence is required of an engineer to go ahead and even provide that level of commentary or that opinion out there, which in turn is going to be a trickle-down effect to the association of a more expensive and a more thorough style of inspection.
I think also, just to kind of echo what Ben and Jonathan have said, the important thing is that board members are, volunteer board members typically don't have expertise in, construction or engineering or architecture. So at this point in the post Surfside, era that we're in, lenders and unit owners and potential purchasers, everyone's trying to get definitive kind of information as to the status of buildings. But, it's important for the board, like Jonathan said, to consult with experts, because although they help manage and administer the association, typically they don't have the expertise to definitively, opine as to structural integrity or habitability.
Thank you, Kristin. I'm just going to touch, before we move on, I'm just going to touch on some key themes in terms of what we've learned from Surfside. The first one, obviously, is that structural issues are now at the fore, right? If before structural issues were the overlooked issue, Now they are in everyone's consciousness, at the top of everyone's consciousness, not just when it's time for the 40-year inspection, but now in the aftermath, every association from inception and throughout its life must always be thinking in terms of a North Star, which is this planning for structural soundness of the association's condominium, and what is the path to get there so that it's economical, there's a reasonable financial plan in place, or if the association finds itself scrambling, how are we going to find the resources and what's the plan to bring the association condominium to a place where we can have confidence in the structural soundness? What work needs to be done? The other theme is, and I don't like to put it in this way, but I guess penny wise, pound foolish, in the sense that associations are going to have to understand, from the members to the boards to management, that the days of looking at an association from the standpoint of how can we just save costs, waive reserves, and avoid expenses has shifted now to spending a little more at the outset will save long term. And so it's not an either or. It is more cost effective to plan and do the due diligence up front than it is to try to be saving money up front and then have to pay at the back end. And of course, there's no price on human life or safety, right? There's no the value is infinite. And so that has to be of paramount importance in the association's planning. So Kristin, with that framework, I guess, please, can you talk about what's happened since?
Sure. So obviously, immediately after everyone was, kind of trying to figure out why and how, and then they're also kind of turned into different parties that are involved with condos, trying to figure out ways to move forward from here. So one of the first things that we saw was in October of 2021 with Fannie Mae and Freddie Mac. They issued temporary requirements for condominium and co-op projects. Now these are applicable. They're basically restrictions that determine eligibility for loans that are backed by units in condominium projects. Now they determined that they were going to be applicable as of January of this year, and they require lenders to take a more extensive review of association records to determine safety, soundness, structural integrity, and habitability. There is, in connection with that, the certain obligations that they issued. They said no loans for buildings with significant deferred maintenance or those who have received a directive from an agency or inspection agency or regulatory agency. These significant deferred maintenance is like considered when you have to fully or partially evacuate the building to do these repairs, and it impedes safety. Now, there is an exception if this deferred maintenance is isolated to 1 or 2 units, unless the unit that is going to secure the loan is the one at issue. There's also requirements with special assessments. Now, lenders are looking at the status of pending or upcoming special assessments for associations. And even if the assessment has been paid in full, the associations have to have documents to show that the repairs are going to be completed before they're considered, or that the repairs are completed before they will be eligible for a loan. The other important key requirement is that buildings that are involved in construction defect litigation or other material litigation are ineligible. And once you're determined as ineligible under these guidelines, you get marked as unavailable in the lender system, and loans will not be able to be issued for units in that property until new information becomes available, such as engineer reports and structural expansions that confirm that the issues and the concerns are no longer exist. Finally was reserve requirements that buildings that budget less than 10% of annual assessment income for reserve are no longer eligible. There were project eligibility waivers issued in the past that have been, the issuance of those has been suspended. And they will no longer issue waivers for large special assessments and pending inspections.
One thing I would ask, Kristin,
Mhm.
what are you seeing in terms of the day-to-day operations of condominium associations in relation to this? Like, for example, there's always been this issue of lender requests when there are buyers of a condominium unit, and lenders have certain questionnaires, et cetera. But how has this shifted those questionnaires in terms of just practical day-to-day operations? And do you have any comments about how associations should be dealing with, for example, new questionnaires that Fannie Mae and Freddie Mac loans require?
Right. So as of January, we started seeing a lot of, feedback from managers and lenders and potential purchasers about this addendum that was added to an existing Fannie Mae and Freddie Mac form. And this addendum focused exclusively on structural integrity, safety, soundness, habitability, and structural defects. And basically the form asks the condo association to opine as to whether or not there are in fact structural defects present at the property, the status of them, the status of any repairs. It touches on special assessments as well. Now, the actual use of the addendum is suggested. It's not mandatory, but the information derived from there is mandatory under the new temporary requirements. So basically, lenders are suggested to focus on obtaining information from associations that relate to improvements, renovations, capital expenditures, maintenance, and the addendum kind of gives like a checklist for them to do that. However, as I mentioned previously, since board members are, volunteer, but it's a volunteer position and they don't necessarily have this expertise, it's better, we believe that it's better for them to basically provide the lenders with copies of the actual reports, maintenance records, in kind of like a structural information package. That way the board doesn't have to make a determination on their own as to whether something is or is not a structural defect. And so reports like ones that Ben would prepare would be the ones you want to hand over so they can read for themselves the words of the expert and come to their own conclusions.
Yeah, the only thing I would add, thank you. Go ahead, Ben, please.
Sure, I was just going to jump on that. So I've seen a whole lot of these questionnaires come in as of late, as I'm sure the rest of our panel has. And it's certainly written from a lending aspect of things and not from an engineering or a technical aspect of things. And you can see it in how simple and how generic it's being posed. And there's a lot of different ways to still theoretically comply with that. And the reason why I bring that up is mainly for some of the newer buildings that don't tend to have some of the egregious structural damage that you may see on an older building that did have deferred maintenance. Let's focus on, let's say, the up to 10-year-old building where you may be within a construction defect lawsuit or you may be nearing your painting cycle. It's in order to comply with that, even producing like a plan set from your engineer to perform any concrete restoration, that could certainly go ahead and be applicable. If you're in the throes of a 558 style of process, I mean, obviously consult with your counsel, but I know in the cases that we've been a part of, we've even produced a separate standalone letter just for this purpose to not shut down the association's day-to-day operations and their, quite frankly, the revenue stream as well, with selling off some of these units and making these transactions occur. So understand that, I mean, that's also the benefit of sending those questions directly over to your engineer, over to your attorney to make those initial interpretations on behalf of the association and have the open dialogue to understand and get aligned on the same page of how will this be presented? Will it just be a formalized package, as Kristin previously alluded to of, all right, these are the documents we have. This is a check in the box for the association. This is a check in the box for the engineer. This is a check in the box for legal. We got it all covered, and we can just shoot it out as necessary as these requests come in. And that's going to be keeping it simple and not bogging down your management team with yet another component that they need to be worried about instead of keeping up with the daily operations.
Yeah, absolutely. Great points. And that package certainly could include a letter from the engineer involved that helps as to what their discipline and expertise is. And working with legal counsel, you can know how to navigate the legal requirements. You know, there's simple technical, there's actually a statute that deals with information requests by third parties in relation to sales, such as lender questionnaires. And the statute talks about how you need to have certain magic words about how the information is provided in good faith, and that could actually protect from liability in relation to those disclosures. And similarly, you can impose an administrative charge to a lender in relation to responding, and even collect some attorney's fees for it to the extent the attorney has to get involved with specific, requests. So all of that is stuff is proper planning for these types of questionnaires, which is going to be a big part of association operations going forward. Thank you, Kristin.
One last thing I do want to touch on before we change from this slide is focusing on that reserve requirement and really the importance of that. And I'm sure the legal partners on this call can go ahead and say a bit more eloquently than I can. But with respect to the state of Florida, at least prior to any sort of legislation or even prior to the collapse, there's no set reserve requirement, a funding requirement by any association, as ridiculous as that may sound on paper. So, which is what really opens up the door for a special assessment. So basically what that means to the homeowners is you're keeping a very low HOA fee, basically for 99% of the time of operations. But when you need to go ahead and do any sort of remedial repair on a large scale, a multi-million-dollar repair, which is not uncommon, that's coming by way of special assessment. That could be $10,000, $20,000, $50,000 to each individual homeowner, which is going to be coming at a huge sticker shock compared to their low HOA fees. And as I understand it, and this might be a good kicking off point, because I know we'll talk about it a little bit later, is that as I understand it, through how this recent bill has passed, and I know the first go around, we all know that it didn't pass. I mean, there was a lot of news buzzing around it. And from my end, I was certainly surprised. And more importantly, what I was surprised by, and I mean, this is really just talk within the industry, so how much validity it has is, I mean, it's truly subjective. But I understand that one of the main sticking points did revolve around this reserve requirement, which quite frankly, to me, is such a hard pill to swallow, because that is the utmost basic part of this. I mean, it's a savings account for your property. It's that simple. You don't need to get more complicated. It's not engineering Mandarin. So I was blown away that truly was the straw that broke the camel's back here.
Yeah, so thank you, Ben. That's it, right. And so what Ben, and just quickly, we all know community associations, condominium associations have to fund reserves in accordance with a special statutory formula, but only as to certain categories of reserves, right? Items whose replacement is over $10,000 individually, right? Roof painting, resurfacing, right? Pavement, amongst others. So basically, those reserves can be waived or partially funded every year with a vote of a majority of a quorum of the membership, which is very easy to obtain. So even though technically there's a requirement to fund reserves, with the waiver, there isn't a requirement to fund reserves in the past. And I want to just add one more thing, which was, even if you fully funded those reserves, and we'll talk about this later, even if you fully funded the reserves, the industry practice in reserve studies was not to fund reserves relating to certain structural long-term deferred maintenance. So you still wouldn't be funding the structural items we'll talk about now. So this is really a good segue to the new legislation that was recently adopted. And so we'll talk about, the legislative developments since the Surfside tragedy and how this has really changed the landscape of Florida condominiums on its head, right? As we may recall, since Surfside, the Surfside tragedy, a couple of things happened in terms of just the cultural mindset. One, we had a legislative a task force from the Florida Bar Condominium Committee, the Life Safety Task Force, headed by William Sklar. And that was appointed by the governor to look into recommendations as far as good changes to legislation that might help condominiums address some of the challenges in light of the Champlain Tower South collapse. And so there were many recommendations, and there was a bunch of proposed legislation to try to address some. And as Ben was alluding to, right, there was a move to prevent waiver of reserves altogether and to require fully funded reserves of all kinds. And that was met with resistance, throughout the state. And even kind of a notion of, well, this was a South Florida problem. It's a coastal problem. It's not an all of Florida problem. And I'm not, but in this, at the same time, we have major litigation, really, unprecedented class litigation concerning the liabilities involved with the Surfside tragedy. And, there was $1.2 billion in settlements in a recently, preliminarily approved settlement agreement. And, there's all types of parties that are contributing to that settlement agreement through liability. And so when it comes to these two factors, right, it was incredible, really. You didn't have any legislation that was approved to address the Champlain Towers issues. And only recently, there was a special session of the legislature that was held where finally there was legislative changes to address some of these issues. And as we think about these legislative changes, I mentioned the litigation just to emphasize what we were talking about earlier, which is the fiduciary duties involved and the duties of the professionals who work with condominium associations, where there's this increased responsibility, I would say. I think it's safe to say. And when we think about that increased weight of responsibility, we have to think about the very specific requirements being imposed by this new legislation and the duty of the boards and professionals to move to make this happen as quickly as possible and to implement these very dramatic changes. So with that,
before we dig into that, I just wanted to point out that we're talking about the Surfside collapse and kind of structural integrity and soundness as related, but it is important to remember that there has been no official release or confirmation as to what exactly happened. I mean, this is just basically, the community kind of started looking into things and different information became available, and this was the response to it. But the National Institute of Standards and Technology is still investigating the actual cause, so we don't know for sure what it is, but these responses are based on speculation and what the information that suggests what likely contributed.
Right, and we're not here to say here's why this happened or not, and we're not here to, in this presentation, say what we think is the cause of the collapse, et cetera. Even Ben, an engineer, right, isn't about to go on record and say why he thinks this happened or not. So, but with that, Kristin, why don't you take us through some of the summary and overview of the new legislation?
Sure, and I'll summarize this real quick, and then Ben can probably expand upon the the more detailed parts. But so basically there are new milestone investigation requirements, which is like checkups for these condo association buildings to make sure that everything is running smoothly. There's certain requirements for buildings with 3 or more stories, and those that are within 3 miles of the coastline must be inspected on the 25th year after being built, and then every 10 years thereafter. And then those that are, further than 3 miles of the coastline have to be inspected every 30 years and then 10 years thereafter. Obviously, there's going to be some condos that are already past their 30th or 25th year, so they're going to need to catch up, and they have until December 31st of 2024 to conduct a milestone inspection. That applies for buildings that were issued a certificate of occupancy on or before July 1st, 1992. So that way they'll catch up and then cycle through the 10-year re-inspections. And then Ben, did you want to discuss exactly what those inspections, look like?
Yes, I'm sorry, I was just typing away on some of these question and answers here. Before we even get into the content of that milestone inspection and what that really means, I want to talk about just the very obvious, just the 30-year and the 25-year, given proximity to coastline. And from an engineering standpoint of things, coastline, we generally think is just along the barrier island that we have, right? Barrier island directly out to the ocean. However, I mean, within South Florida, we also have the Intracoastal Waterway. Is the same salt water. It gets washed in and out twice a day. I mean, with the tides. I mean, for all intents and purposes, while it is not only generally stipulated as a coastline, my engineering interpretation of that certainly would qualify as a proximity to the intercoastal as well, within that 3-mile standpoint, because it doesn't act any different. Plain and simple. You have the same salt-laden air, it has that same sort of aggressive environment that will take its toll at a higher rate or a faster rate than something if you were going to be in the middle of the state, for example, around the Orlando area, and you're not around a lake. So I do want to go ahead and address that aspect of things, which may have some added clarity years down the road by way of legislation is concerned, if they do get more engineer involvement as far as writing of an amendment of the bill, things like that. But when it boils down to the milestone aspect of the reporting, this is essentially a derivative of the reserve study, but is a more technical derivative, right? This makes it more of an engineering style report and a phase 1, phase 2 style analysis. I don't know if our next slide actually talks about that, but generally speaking, and without getting into too much detail, because we will talk about it later. Oh, here we go. Thank you. So phase 1 inspections is going to be very similar to what you have right now for just visual only inspections. You're going to be doing very similar to what you have within the current 40-year process, but you're expanding on the actual components. You're focusing on these structural components, any foundation aspect of things. And one important thing with respect to foundations alone is that within South Florida, we mainly have deep foundations, or we have pile foundations. Now, those go several feet underground. And as you can imagine, I mean, within a phase 1 inspection, you're not using an excavator to go ahead and open up each and every pile to see its overall condition. So you understand the limitations that may exist out there. However, as an engineer and performing a lot of these visual only evaluations, the buildings will want to go ahead and tell you or tell the observer what's going on. They're very good at doing so. So within these structural components, seeing a certain style of crack, a certain width of crack is going to be extremely telling, and only provide so many different options as to what that cause may be, which directly goes towards the phase 2 style of inspections. If certain questions arise from, let's use that same example of the crack. Let's say this could be a structure, a rebar placement issue. This could be an overloading condition, or this could just be a one-off, somebody ran into it with a car. Let's throw something ridiculous out there. The due diligence that will occur to go ahead and narrow it down to a singular answer is going to be found in phase 2. That's going to be found by way of, okay, let's do GPR on the actual, on the pile or on the column. Let's see what's going on. Do you need to shore up the area to expose out some of that reinforcement to see what level of corrosion do you have? Because the level of corrosion is going to be extremely indicative of how much load that column or that bearing component is going to be able to handle. If the corrosion is going to be too great, I mean, you're really not going to have anything left there once you clean off all that corrosion. That's going to be very, very important to know. And also what has been showing the talk as well is, okay, well, what's going on with the earth? What's going on with the ground below us? So having someone like a geotechnical expert come in as well is starting to become more and more commonplace, as opposed to just relying upon a structural engineer. So having that team available to go ahead and answer those phase 2 questions is going to be crucial from an information standpoint of things, and also from a planning standpoint of things. It's the same concept as like going to the doctor, for example, and running blood work. It's beneficial to go ahead and know what you have so you can plan for the future and maybe deal with what you have right now instead of plan in place. So it's the same general concepts coming into effect. And I'm happy to see that we're really moving towards that route, because one other thing to go ahead and consider, which has been misconstrued within just the condo world as well, is the true involvement of an engineer and what does that really mean. And an engineer doesn't make a dollar more if there's an issue or not an issue. Now, they're not financially tied to anything like that, similar or contrary to how a contractor may be, for example, if they were the ones responsible for doing the reporting. As an engineer, we've taken an oath to go ahead and protect the public, protect life. And that's ultimately the forefront focus of every single engineer, licensed or not licensed, whether it be in the state of Florida or nationally. So having that objective voice is really going to be crucial. And I strongly encourage you all to just have the open dialogue with your professionals, because they're the ones that have the technical know-how to really discuss this issue effectively.
Thank you for the engineering perspective. Really, really important. I just want to touch upon some legal details in terms of the implementation and the day-to-day operations of the association in relation to the milestone inspections and the new law. For example, the law specifically, it's one thing, there's a fiduciary duty, obviously, the directors have. The law specifically states that if the board is the cause of a failure to comply with this requirement, that is automatically a breach of fiduciary duty. And if the board is ready to move forward and a community association manager is the cause of a failure to comply, then that is a breach of fiduciary duty, or that is considered a statutory violation by the community association manager. And so as we move forward in terms of just contracts with community association managers, it's important that that's going to have a requirement to comply with these specific inspections, these specific requirements in the statute. Also, there are certain duties to turn over these reports to the building officials, right? There's a role for local government expressly stated in the law. For one thing, the local governments are invited to weigh in with timelines, deadlines, and a process for implementation at the local level of the milestone inspection requirement. For another, there's a duty to report to the local government concerning the milestone inspections and to turn them over. The local municipality building department triggers a milestone inspection deadline by giving a notice of the requirement to turn over the milestone inspection. And lawyers and engineers are still working out, mainly lawyers and boards, that we're still working out the details of, well, when is the deadline triggered? Can you do a milestone inspection early? Can we use this? Can we use this engineering study and repurpose it as a milestone inspection if a visual inspection was done and it covered the requirements? Can a new report be issued based on that visual inspection that covers the milestone inspection requirements? Or do we have to do another inspection and report because the notice has come from the local government? And we're looking for guidance from the local governments, and we're also analyzing these issues and interpreting them as lawyers. And so it's important to talk to legal counsel. Obviously, it's important to get a head start on all of these issues as much as you can, because there's going to be a run to get engineers in place, to get architects in place, and there's going to be a real issue of how much can these professionals do in a short amount of time. And there's going to be just a practical dilemma of the cost and time frame to complete these requirements.
I think it's also important to realize that obviously these repairs, the mandatory reserves, the maintenance of foundation, windows, plumbings, those all cost money. But it's important to keep in mind that the actual milestone inspections themselves cost money, and to hire these experts. And then, as Ben was saying, in the event another phase is necessary or a different expert is required to come evaluate a specific aspect. So the association should take that into consideration and plan for these expenditures, and maybe even add a reserve line item for milestone inspection funding, so that little by little over time, we contribute to this, savings account for the milestone inspection. So come 10 years from now, everyone's not hit with a special assessment and all sales are halted and we get into all of that. It's better to plan ahead and portion out money little by little now, so that when the deadline comes for these inspections, everyone's not in shock with the amount of fees that are required.
And there are many associations that are going to be scrambling right now with their financial issues. And so the time to start financially planning for how to pay for this whole process, and of course, it could lead to the necessary remediation. And as Ben explained, if defects are identified and that have to be remediated, there's a finite amount of time to do it once that's been reported to the by the engineer. So planning immediately should be in place to fund this whole process. Kristin, great point.
Absolutely. Even adding on to that and just thinking about overall scale. Now in performing these actual engineering evaluations, we're talking about on the orders of thousands of dollars. And now when you're talking about repairs to the contents of these reports, on the worst case scenario, you're talking millions of dollars. But from an overall design process, how does this go? Well, what's step one? What's step two? What's step three? Right? So the step one is always going to be engineer based as far as doing an evaluation. Step two would be identifying what you have and developing plans and a request for proposal out for contractors, doing the overall design. Those are two engineering components that need to get done on the front end. Again, we're talking orders of thousands of dollars, but that takes time. And you want to make sure you have that foundation, because that plan set that you get signed and sealed, once you have that as a signed and sealed document, that's a good document to use. You can go ahead and bid that out. Now, whether you bid it out today or a month from now, that's up to the association's discretion, but at least you've done the heavy design legwork now. So you can go ahead and bid it out to contractors. And granted, we know, good contractors and good engineers are busy right now, right? But ultimately, you're getting those numbers to the association sooner than later. You can have those dialogues sooner than later. You can plan sooner than later.
That helped. That brought another point to my mind, is that, in addition, obviously, to these expert fees, along with that, you're going to have legal fees, because you're going to have to hold meetings to approve these contracts, have your attorney review and revise contracts, make recommendations in the event that there are urgent repairs that need to be done. So just another reason why planning and budgeting for these costs now can help in the long run.
And attorneys are critical resources, throughout this process. And associations really should look at the legal counselor as a partner in this process, where we should be involved from the outset, helping in terms of making sure, working with the engineer to make sure the RFP is going to have the crucial legal terms you're going to want. So you're bidding apples to apples, getting ahead of the budget of the project, thinking practically, thinking legally, strategically. So like the engineer, the earlier the legal gets involved, obviously the engineer is the starting point of this process, but the lawyers have to be involved throughout. The left hand has to know what the right hand is doing and guiding the association. Kristin,
and if you think about it, before we move on, Jonathan, I just want to point out, right after Surfside, a lot of the next steps were basically different, parties trying to absolve themselves of liability. The temporary requirements are basically lenders trying to shift liability onto the association. We've seen managers that want, certain resolutions signed by boards as to how to respond to these lender addendums. So everyone's just kind of trying to shift responsibility, liability, and kind of, in the event that anything were to ever happen, everyone did what they were supposed to do. So it's definitely important to have legal counsel involved to make sure that everyone's, proceeding in the best manner.
Well, absolutely. Reliance on experts, documenting business judgment, it's all crucial. Can we go back one slide? Because I think we now have to talk about the reserve study, the structural reserve study requirements. Ben, why don't you quickly take us through the structural reserve study, because this is a huge piece of the new law, separate from the milestone inspections, where, well, Ben, you could speak to it, but basically the new law creates a new type of reserve study, mandatory every 10 years, that essentially creates new categories of mandatory reserves based upon a very technical analysis by engineers like Ben. And go ahead, please.
Sure. So the big change, what we're talking about here, is going to be looking at load-bearing walls and structural members. But one unique thing that I'm involved in a whole lot, given a lot of forensic work that we do, is really waterproofing and exterior painting. Now, a lot of complex condominiums have an elevated pool deck, for example. Now, a lot of that design is going to be a split slab construction, meaning that you have a structural slab, waterproofing, a topping slab, and then whatever pavers or whatever architectural stuff you have on top. But your protection is at the structural level. That is not a visible component by any stretch of the imagination. That is only observed by way of opening up holes in that overall cross section that I just laid out to observe its condition. And now, with respect to that, there are economical waterproofings versus a state-of-the-art or a top-end waterproofing. And when I say economical waterproofings, I'm talking about something that may only have a warranty and also very closely an associated lifespan of about 5 years. Now, the cost of removal and replacement of just putting on waterproofing, be it the 5-year product or a 20 or 25-year product, is not that different. The labor is essentially the same. You're just putting on more material, and that's what really comes at the difference. But the biggest burden and the biggest cost with respect to that repair is going to be getting to that waterproofing, exposing that, removing your travertine, getting rid of your topping slab, pulling up planter boxes, and then exposing out that waterproofing. That comes at several times more than just the cost of removal and replacement of the waterproofing. Same with load-bearing columns. I mean, like, depending on, again, what the engineer sees out there, it may go ahead and result in the engineer needing or requesting or recommending that a redesign or a confirmation of design be undertaken to go ahead and answer those questions of, all right, I'm seeing a whole lot going on here. It's telling me that we might have, again, might have some overloading, might have some concrete quality issues, and now trying to go ahead and answer that. But what does that really mean on the overall health of this property? So those are the two big things. And in addition to that is, with respect to reserve studies, they also take a very narrowed focus. I mean, they have your $10,000, but they also have a time limit or an expected useful life limit. And that limit is going to be hovering around 30 years. Now, the overall structure, the building structure, is well in excess of 30 years, as we all know. There's several structures within South Florida that greatly exceed that and look beautiful. So removing that upper threshold is crucial, and it allows for a more engineering and technical driven analysis with respect to this approach.
Yeah, so just to carry on that point, this new reserve study requirement requires some level of that technical analysis by an engineer or architect, right? That's critical for the reasons Ben mentioned. Now you must fund reserves for these structural categories of reserves. They are enumerated in the law and also include any other item that has a deferred maintenance or replacement of cost above $10,000 and that affects the listed structural items. So no longer can associations waive or reduce the funding for those structural reserves. Important to note that I think there's an interpretation of this law where the association can still have some room to waive or reduce reserves for other non-structural categories of reserves to the extent they exist. But that's a different topic. For the purposes of the structural reserve study, those items must be funded. And it's important to keep in mind, as Ben was saying, reserve studies to date haven't necessarily captured the replacement cost for these items because of that extended useful life Ben was referring to. And because in the industry standards for reserve studies, that just wasn't something that was looked at. And so it's not just that you can't waive these reserves or reduce the funding, it's a whole nother layer of additional reserve expense on top of some of the other components. So it's going to naturally increase the cost of reserves. I think we can move on now to the next slide and talk about some of the mandatory items that developers must provide. The new law affects the turnover process as well, Previously, developers had to provide an engineering report concerning several types of components and their useful life. As the PowerPoint shows, that now has to change. Now there's got to be a milestone inspection, and also there's additional components that has to be incorporated into the developer's turnover requirements. And the developer has to do a structural integrity reserve study like we're discussing, not just the report they were doing before. At this juncture, I would just like to tack on, and Ben, I know you're very involved in construction defect litigation, as is our law firm. I think an important thing to mention while we talk about developer obligations is just the critical role of the 558 and construction defect lawsuit process in setting the stage for financial and structural health of a condominium association. At the beginning of the association, a lot of these defects are not manifest yet. They're latent in nature. There's a statute of repose that will prevent claims after 10 years from certain benchmarks, such as the completion of construction or final payment. And so it's imperative that associations figure out these problems before they can no longer sue on them. That's why often destructive testing is recommended. In high-rise towers, always, destructive testing is recommended to get beneath the surface. And Ben can speak more to this briefly. Just if you don't pursue these claims now, it's a cost that will live with the association throughout its lifespan. And now is the time to recover it from those contractors, design professionals, and the developer that are responsible for it. So the days of minimizing the 558 process, trying to avoid it because it's expensive, trying to avoid it because it makes it hard to get a loan, those days are over. The construction defect process is the last chance to collect money to fund some of these critical initiatives. And also it's an opportunity to discover problems that, if not remedied timely, can exponentially get worse. Ben?
Yes, and thank you for that great kickoff. So a couple of things I do want to make mention of. So with how the current 718 is written, the report that is provided over to the association, or the engineering report that's provided to the association, certainly lacks a lot of content. Now, the requirements are extremely low, and when you see a report of that standard or of that style, you're talking about something that's very thin and only really comprised of what's the replacement value in today's dollars, what's the expected useful life, and is there anything where we currently stand at now. That's basically it. So it is extremely light. Now, by having a structural integrity reserve study as part of this, I mean, I think we're going to be seeing a lot more good content, good material being transferred over to the association once they get the proverbial keys to their new car, so to speak. Now, with reference to the overall 558 process, just like Jonathan said, that is really the only current avenue to get any sort of reparations for the manner in which the property was developed and constructed on the front end. Again, I mean, with how we currently have it, from a reserve standpoint of things, even with the developer side, they can go ahead and develop the property and may not have the requirement to go ahead and leave you with much or anything on the front end. So really doing a deep dive and understanding what your issues are sooner rather than later. Again, I'll go ahead and I'll use that same doctor analogy of doing the blood work early, knowing what issues you may have. And if for whatever reason you're born with some mild birth defect, I mean, and keep it in building terms from the get-go, you know what to do, you know how to plan for it, you know what to keep your eye on. For example, a lot of properties built on the water have a seawall. A lot of times when these new properties are developed, that seawall is the actual wall itself, actual wall itself is not a brand new wall. That's going to be the old existing wall. It'll just be redesigned so that the load is being taken from new piles, which is perfectly acceptable. And I'm not suggesting that it isn't, but understanding that you have a 30, 40-year wall, but a 1-2 year pile. So understanding that this will degrade faster than the batter pile is going to be crucial, and good information to know on the front end while you're doing your due diligence and evaluating what condition it truly is in.
Thanks, Ben. Kristen, I think we should just jump to local government updates since we are near the end of our time. And then we can talk about financial impacts. Just quickly to talk about some of the local changes. We talked earlier about disclosures in relation to lending in condo transactions. And of course, there's also disclosures to potential purchasers. And there's a general theme of increased disclosure in the aftermath of the Champlain Tower South tragedy. And so this ordinance is indicative of this. Miami-Dade has adopted an ordinance that will require an annual written registration and filing of critical documents to the county, and the county will maintain a database of information about the condominiums in the county. And so this is going to be maintained by the county and accessible on the county website. And failure to comply is going to be punishable by fines, and different failures in the processes required are different, violations. And what the ordinance basically requires is registration with critical information about the association, including, and it's very specific, the property manager, the name of the directors, a link to the website, and then you have to upload certain documents, governing documents, plan documents relating to the planned capital projects, financial statements, annual budgets, certificates of insurance, engineering reports on structural status issues issued within 10 years. So all engineering reports in the association's possession on structural issues within the last 10 years, location of building permits for work. So it's like, there's this whole amount of information that will have to be uploaded. It's going to have to be done by February 1st, 2023. The time to start planning for this is now, in terms of marshaling documents and records, making sure that the association understands what it needs to do to comply, and that the wheels are in motion for that compliance.
I think that the structural information package that we mentioned earlier that to provide to lenders, this is just another example of how that information can be used. If you compile this information in a ready-to-go packet, these are official records, it's going to serve multiple purposes. You can provide it to the lenders, you put it on the website, you give it to owners for official records requests, but you also can use that information for the Miami-Dade County registration, because you would obviously have to supplement with the other stuff, but you already have your inspections, your reports in a ready to go pile, so that it minimizes and it just keeps getting updated as new information comes in.
I think, and again, this goes to, the issue of disclosure. Having information readily available will assist the sale of units by owners, right? And not to mention compliance. Of course, Miami-Dade County also still has the 40-year recertification requirement, and we'll be looking for updates to that program, because I'm sure as we move forward, the county will be adopting ordinances to incorporate the milestone inspection requirements and maybe to synergize those a little bit. They're different processes, they're each unique. And so we can't forget that that's also something that has to be on associations' radars. So with that, I think we should talk about financial impacts, which I think we've talked about throughout. To summarize, it's a different world for condominium associations now financially. The costs are going to be significantly higher. That said, for associations that plan a certain way, there is a way for newer associations to spread the costs more equitably over the life of the condo, rather than this issue of random timing of major special assessments that's going to happen for the older condos that aren't financially prepared, where there's going to be really in the next several years a significant financial hit, where there will have to be a major special assessment of tremendous magnitude. Associations are going to be looking to borrow money and to fund these special assessments. And so associations cannot delay in planning these financial maneuvers to shore up the balance sheet to be ready to comply with all these requirements. Kristin, Ben?
Yeah, one thing I'd like to tack on to that, for some of these older properties, it does seem like a very big undertaking just to basically start from zero and you're at year 30 or 40 to go ahead and build up that reserve. Quite frankly, just looking from the treetop level, it seems almost impossible without some sort of state involvement of by way of grants or something similar. because it just may not be within the realm of possibilities. One thing that's more possible in that scenario is maybe bulk buyouts by developers, which we're slowly starting to see some of that occur within these 50, 60, 70-year-old properties. And I know that these individuals that live in these properties, I mean, we represent a fair amount of them as well, but I mean, they're effectively losing their homes, and they'll never be able to live at that location, or that physical location, or anywhere near that location in the foreseeable future, even though they are getting a great deal, so to speak, if a developer does come in and buy. But you won't be looking at the water. You won't be anywhere near the water at that point in time. So I'm curious to see how this whole thing will go ahead and develop. I'm happy that something has already been put in place formally, but this is going to be just like with the associations, how they're going to be going ahead and doing their work every single day to meet these current standards. It'll kind of be a little bit of a moving target from the legislation standpoint of things, because they're working on this the same way as the associations are, excuse me. So hopefully within the second or the third revision, that we get something that's going to be nice and ubiquitous across the playing field, and something that's obtainable and, quite frankly, physically possible for every association to go ahead and meet.
Yeah, I think the financial concern of buildings that are already kind of behind the ball on this is really going to continue to develop over the next few years. I mean, obviously, like Ben said, there is going to have to be some kind of assistance, because, you know, there are lender requirements that may end up applying to loans to the entire project. And, you know, it could get tricky with lenders trying, you know, not wanting to issue funds to buildings that have serious structural issues, which some may do. Now, there's also, you know, line of credits which are available, and that can, you know, help potentially kind of gauge, you know, it puts the association in a position where they don't have to take out $15,000 loan right away, or $50 million loan right away. They can gauge based off of contracts how much they need, and draw money, you know, as necessary, so they don't end up in more debt than what is required. But it's going to be interesting to see how lenders respond to this situation going forward.
And one last thing with respect to that, and I know we're going back to a similar theme of having this packet ready. Like, I mean, each association, especially each older association that will be seeking some sort of a loan of any extent. I mean, looking at your association, like, and playing devil's advocate of how how solvent or how good of a candidate do I, Association A, look like? Do I look organized by way of having all my ducks in a row with my engineering reports, with my plans, with my reserve studies on time, or is it in shambles? And just trying to present that in the most effective light and promising light is really going to give that association a better shot of getting a loan in a not very loan friendly environment, unfortunately, with what we're in right now. And I don't see that to be any better in the near future.
Yeah, no doubt about it. And working with counsel in terms of preparing to seek a loan is critical in terms of doing it the right way and complying with lender requirements and making sure the terms make sense. You know, lenders are going to want a collateral of the special assessment, but you have to ensure that their collateral doesn't include mandatory reserves. There's a lot of technical issues with that. So, you know, again, the sooner the association works with legal counsel and gets its ducks in a row, so to speak, as Ben was putting it, the better. And Kristin's right, lines of credit are a great resource. So I think with that, we have to conclude. I think we're out of time. Again, I would like to thank everyone participating, the Brickell Homeowners Association, all the attendees. And again, this is a solemn and important topic. And there are very important lessons learned from this. And so going forward, let's just continue to appreciate the weight of responsibility on our shoulders to try to do things the right way to, you know, protect associations and condominiums.
Yeah.
Thank you, everyone.
Kristin, Ben?
Thank you, Epic.
Yeah, I mean, this was a great topic. I hope this was beneficial to everybody, everybody on the call, certainly. And yeah, I mean, the silver lining is that hopefully, I mean, something like this never happens again. and through the collective efforts of all professionals that are involved within this condo and HOA world, that we can really get something really good going here that'll make sure we're okay in the future.
And there were a lot of good questions on the chat. You know, they can be sent to us thereafter. This recording could be made available by the Brickell Homeowners Association. So maybe there could be follow-up thereafter in response to certain questions. So again, thank you so much, everyone.
Thank
Bye.
you, everybody.
Thank you.
Thank you, everyone.